the City of Greenville, Greenville Human Relations, Sustain and Way, and other organizations to give a 90-minute forum about pathways to homeownership in our community called Nicholtown. However, tonight we have a very special presentation that can impact individuals all over the United States. Our forum usually features advice from housing experts about homeownership, affordable housing opportunities, homeowner buyer education, and more. These forums will be held on the second Thursday of each month beginning at 6:30, so mark your calendars. Every month we will have something to present. Tonight I will be your moderator, and our producer is Alicia Brewster from Sustain and Way. She will also serve as our audience supervisor, who is our chat monitor and run the survey. And she will be co-technical director with Oscar Bennett, who will be muting you, running the recording, and offering us on Facebook Live. A few housekeeping details, especially for those of you who may not be that familiar with Zoom. If you move your cursor anywhere over the Zoom picture, you will see a taskbar appear at the bottom. During our presentations, we'd like to allow the presenter to complete the presentation before we start questions. So there is something called a chat at the bottom. If you will click the chat icon, a chat description will pop up, and you can type your question in there if you feel like you need to put it in before the presentation is over. But we still won't take the question until after the presentation is over. When the presentation is completed, you can go to reactions. If you hit on reactions, you can raise your hand like so, and we will call on you to raise your question. When you have raised your question, then you can hit the reactions button again and lower your hand. Also, there are things like applause, and if something you find particularly funny, you can laugh out loud, or you can just say, hey, thumbs up, I really like that. Good point. So there are all kinds of reactions that you can get familiar with. We have approximately 20 participants tonight. Hopefully we'll get more as people join from around the neighborhood and from around the country, because like I said, this is a very important presentation tonight. I would also like to remind you to please mute yourselves and stay muted during the presentation, because sometimes background noise can interrupt the presentation. Check yourself from time to time to make sure that you are muted, because as we move the cursor over the image, sometimes we can accidentally hit the video or the microphone by mistake. If we start to get any feedback during the presentation, we'd like for you to also stop your video, because that will allow Zoom to basically give us more cycles so that we can make good video presentation and audio. I'm going to put in the chat some information about the Center for Heirs Property Preservation, how you can contact them, reach them, and some information that is being provided about what kind of services you can get for them for free and what kind of extended services you can get from them. So with that, and without any further delay, our guest presenter tonight is Mr. Joshua Walden. He is in Charleston, South Carolina. He is an attorney and the Chief Operating Officer for the Center for Heirs Property and Preservation in Charleston, South Carolina. He has been practicing law for 20 years and has been with the center since 2009. He has a wealth of information to bring us tonight. And as I said, this is going to be great stuff for everyone. So please help me in welcoming our attorney presenter for tonight, Joshua Walden.
Thank you, Mr. Mitchell, and thanks, Ms. Brewster and Sustaining Way. It's really an honor to be asked to present on this topic. We're not quite to the upstate yet as far as our service area, but we are striving to get there. Roughly 7 years ago, we served 5 counties, and we currently serve 22. So we're making our way towards there. We're just about to get to the Midlands, and we'll keep going. But this is the heirs property. What my goal is tonight is to give you some information about heirs property, and this is a topic that could go for a full day. Attorneys take classes for a full day to discuss the issues relating to heirs property. So all I want to do is give you some basic overlay of what the law says, and maybe we can dispel some myths. Maybe we can cut through anything that you might have heard about heirs property that maybe is or isn't true. And also, I really love the fact that we're going to have a Q&A session, because I think sometimes the best way to convey this information is allow people to ask questions, and what you get from the answer can say a lot as well. So it looks like I'll probably go to about 7:15 with the presentation, and then we'll transition to the Q&A. So what is heirs property? One of the first questions is, and what we often hear is exactly what is heirs property? Well, the best way to think about heirs property is to know the way the state of South Carolina tracks land or home ownership, right? So for every piece of property in South Carolina, whether we're talking about a home or whether we're talking about 400 acres out in the middle of a rural area, there's what's called a chain of title. In other words, you should be able to go to the Register of Deeds office, you should be able to go to the Clerk of Court's office, you should be able to go to the Probate Court's office, and you should be able to track the ownership of property over time, right? And usually there's 2 ways property goes from one person to the next. Either they sell it or give it to them, and they sign a deed, and that deed is recorded in the Register of Deeds office, and forever that deed is of record. Even if the original is destroyed, that deed is of record. Or someone dies owning property, and at that point, someone is supposed to administer the estate of that person in the probate court. So there's a record created in the probate court in the county where the person passed away as to what happens to their property when they die. Now, if someone has a will, well, they've given instructions on how they want that property to go. If they don't have a will, the state of South Carolina has written a will for all of us, whether we know it or not. And it's the law of intestate inheritance through the probate code. It basically says if someone dies without a will, this is who inherits their property. And that can make for some strange outcomes. And we're going to get into that a little bit later. So I'll go ahead and take this opportunity to tell everyone you need a will. Doesn't matter how much you own, what interest you own in a piece of property, you need a will. Otherwise, you're letting the state of South Carolina decide what happens to your property, whether it be land or whether it be just your personal property, when you pass away. So given those records, all those records are supposed to occur. So over time, you should be able to take any piece of property and track it all the way back to the King's Grant. I mean, you should be able to track it 100 years back and go from deed to deed to deed to deed oh, there is no deed coming from this person, but you look in the probate court records, they died, and their will, or even if they died without a will, the intestate law said the next person are the owners. But here's what happens with heirs property. Somewhere in that chain, someone dies owning the land, and they didn't have a will, and nobody ever probated their estate through the probate court. And then time starts passing after that. Now, for purpose of tracking who the owners are, you can only go so far as the record. So if John Smith died in 1950 and he had a wife and 5 kids, but his estate was never administered, whenever you search the title to that land, you'll find that John Smith was the last owner, even though he was last on this earth in 1950, because that estate was never probated. The record of who inherited after him was never created. So that's why his tax bill, the heirs to John Smith may have a tax bill now that says heirs of John Smith, or estate of John Smith, or John Smith deceased. And then we'll have that little CO, care of. And all that is who has been identified as we're going to send the tax bill to them, right? So with heirs property, very often the tax office does not know who the current owners are. So what happens is when John Smith dies, and when someone dies owning property and they don't have a will, the law of intestate inheritance takes over. And for our purposes, it basically says in South Carolina, depending on what year we're talking about, your wife or your spouse is going to inherit, or your husband or wife, your children are going to inherit, which isn't that messy, right? When we're thinking about it, we're thinking about trying to get that hashed out and resolved. It's not that messy, but you go one more generation. Maybe mom's passed away, and maybe 2 of the brothers and 2 of the sisters have passed away. And if they didn't have wills, what can happen at that point is then spouses inherit. You know, to give you an example, if I pass away, I got a wife and 1 son. I pass away without a will. Maybe I've inherited land from my parents. My wife will inherit 1/2 interest. She could get remarried, and that second husband is going to inherit an interest in my family land. That second husband has kids with even someone other than my wife as a second wife. Those kids are going to inherit when he passes away. So it doesn't take too long down the family tree as those interests, because there is no will, start trickling down, that you're going to have a lot of folks who own this property who in no way are related by blood to the original owner, or wouldn't even be considered family in any real way. And that can make it extremely difficult to resolve a problem when you're trying to get everyone together and decide and come to an agreement on how to address the issue. Um, the ownership of that land, when you are an heir to heirs property, there's an interesting form of ownership and interesting rights that are attached. And probably the best way to think about that is if you had 10 heirs and 10 acres, right? Common sense and logic says everybody owns an acre because you got 10 heirs and 10 acres, but you don't. Everybody owns 1/10 interest in the whole 10 acres. They all own an unequal share, an undivided equal share in the whole. So one heir could go right in the middle of the property, build a house, because nobody owns a piece. They own an interest, which again makes it problematic, makes it difficult to try to get things resolved when the family's coming together. Um, another thing that happens with heirs property is, again, as people pass away, that group of owners, they're called tenants in common. They're the heirs, but legally speaking, they're tenants in common, so they own that interest I just talked about. As each one of them dies, their interest goes to someone. And that group just keeps growing and growing and growing over time. So if we're within one generation, if John Smith's son is trying to resolve the heirs property problem, maybe he's just dealing with the fact that mom's passed away, and maybe some of his brothers and sisters, and maybe he's dealing with his nieces and nephews and that sort of thing. But if it's John Smith's great great grandchild, we could be looking at 70 to 75 people, or 100 people, or just depending on how large the family is. So we're going to get into a little bit later how to prevent that kind of issue. But but that's sort of the heirs property and what heirs property is in a nutshell. It's about what the ownership is. Okay. And it's basically property collectively and group owned by a group of heirs, family members. Some people who've inherited may not even be blood family, but they inherited through intestacy law, and they all have an equal, undivided interest in the whole. Everyone has equal rights, and to that effect, somebody who owns 10% and somebody owns 90%. If you ever came, even if there were just two heirs, you had one owning 90%, one owning 10%. The 10% has just as much right and authority to use that property in any way they want to. The only time those percentages come into play would be if they were to sell the land and the money was divided up. The one who owns 90% would get 90% of the sales price and the 10% would get 10%. But as far as usage and authority and right on the property while it's in the family, there is no difference. And that's one thing that very often, very often can come into play when you're dealing with one of these cases. Um, the Some of the problems that we see come through when folks come in, and that's whether they're coming in and it's one generation. It was mom's property or dad's property, so we're only talking a pretty recent event, or whether we're talking multiple generation. It was great great granddad's property. The fact that there's unclear title, like I said, that record does not exist as who the owners are because there was no will and there was no estate ever probated through the probate court to create that public record for purposes of tracking the ownership, right, across time. Um, when you cannot, and when that happens, you can't prove who the owners are, right, to whoever you're dealing with. So some of the things that come up is one, heirs property owners cannot access the value in their home like most homeowners can, or value in their land like most landowners can, if we're talking a rural parcel, because they can't prove ownership. So there's no way to access the equity in the home for as far as a bank, purposes of home improvement, or for purposes of building on the property, using the property as collateral, doing it that way. The bank's not going to do anything because there's unclean title and they can't prove who the owners are. Other things that come up with the problem of heirs property is very often, particularly with weather events, we're seeing a lot of people who have heirs property have a hard time accessing FEMA funds for purposes of home repair, and that's not just on a federal level. That can be on a state or even a local level. Most of those services revolve around being able to prove you own the property or you own the home, and it's proven really problematic for a lot of heirs property owners along the coast. And as y'all know, I don't have to tell you that those weather events just don't stay on the coast; they affect people in the upstate and in the Midlands as well. So you may have run into that depending on where you live. Um, and another problem is the tax assessments. Very often, heirs property owners have a hard time getting the assessments 4% primary residence through the tax assessor. They have a hard time getting the homestead exemption uh, uh, through the county because one of the reasons you have to prove you're the owner, and obviously that can make a huge difference in the amount of taxes someone pays on their property. Um, that is one of the primary causes for land loss, particularly with heirs property or home loss. After a certain point, the taxes can just get out of hand, particularly if it's and when you're talking about a city level or urban level, if you're talking about gentrification, where some of the adjacent properties are assessing higher and higher, driving up the taxes all around it. If you can't access the 4% or the homestead exemption that'll keep your taxes low, it's going to be taxed at 6%, and those assessments around you have even more of an effect on the cost. And so at some point, it can become just too difficult to hang on to the property, particularly if it's a property held by the family and maybe only one person lives there, or the one person who lives there can't afford that level of tax, and maybe some others don't want to contribute because they don't live there. There's a lot of things that can go into that. I will say also the problem that sort of ties into how having heirs property can can lead a family or lend a family to losing the property is because of that family tree growing and that group. And I call it the family tree because sometimes I shouldn't, because when you get into 2 and 3 generations of it, you often have people in there who aren't family, like that example I gave about my wife's future second husband, right? So, he's going to, now that's not going to happen because I have a will. So that's one way to put an end to that scenario. I mean, if you have a will, you control the way things would go. So we've looked at sort of what constitutes heirs property, what heirs property is, some of the problems associated with it, and some of you, if you have heirs property, you may have experienced these. It's interesting. A lot of times in the more rural areas, the reason you see a lot of manufactured housing on heirs property is because generally that's considered personal property, so they don't need collateral, right? You can put the manufactured home on there, put a well and septic in or tie in if you're in that situation, and they'll just bring about what's called a claim and delivery action. They don't need a mortgage, right? They can just come hook it up and pull it off the land. Um, for a home, they're going to want a mortgage if they're giving you money for purpose of collateralization, and you got to have clear title in order to do that from any reputable lender. Um, so the segue for this is really into how does all this work in families losing land, because we've all heard about heirs property heirs property families losing land, people losing land that have been in the family for 100 years. And a quick aside, I will make this comment. Very often I hear that heirs property, and I think what people often think about is heirs property always being that multiple generational property that's 100 years old or started shortly after emancipation. And there are tracts like that, certainly. But heirs property is created every day because of lack of a will and lack of probate administration of an estate. So very often, the folks that come through our door, we're talking about people who are within one generation of the problem. And thankfully, they're coming in because it's one generation. And they're not walking in somewhere, or their grandkids are not walking in somewhere 40 years down the line, and it's 100 heirs. Um, so how can this lead to losing property? Well, one way is tax sales, sort of what I was talking about earlier. Uh, Gentrification, whether that's occurring in an urban setting or in a rural setting. I mean, the rural landscapes used to be somewhat insulated, but as places like Boeing or BMW or if they put a plant somewhere, all the all the property around a plant like that needs infrastructure, it needs place for workers to live, it needs everything that goes along with that, and there immediately start pressures in the more rural areas as well. So I don't think the rural areas are any more. I don't think the rural areas are necessarily immune uh, to that gentrification process or that process of development that necessarily drives up values to the point that a lot of folks who were there originally can't stay. Um, so tax sales, and again, one of the reasons the tax sales become more prevalent over time is that family dynamic that's created as that group of owners grows. As people pass away, you know, I could tell you from the cases I've handled, the families I've worked with, if you're within 1 or 2 generations, people have a memory of the property, whether it's a home or whether it's a rural tract. I remember mom, dad, granddad, grandmom. I remember something about the land that made it something more than a commodity, right? It made it part of the family almost. But as that group grows, and then you get people in that group that aren't even family, then you get people who just are further and further out and removed from a close emotional tie to the property. You invariably the property gets more vulnerable, and I'm gonna tell you how that happens. One, tax sales, people can no longer pay, or they just don't see the benefit in paying if there's one home and there's 50 heirs, and everybody's living somewhere else, or maybe one person's living there, and you just don't get the kick in like you used to, right, for the taxes. Another way is forced partition sales, and this is the thing that most people talk about when they're talking about heirs property. If you ever wonder how a developer can get their hooks into land, particularly rural land, or even a home in town, uh, remember we talked about that group of owners are what's called tenants in common, and they each have a certain set of rights. So that example I gave about 10 heirs and 10 acres, each owning 1/10 interest. Well, another right that the owners have as against each other is the right to bring what's called a partition sale action. In other words, I'm bringing a court action against the other owners. And if it's all family, then it's one family member or a group of family members suing the other family members, and they're requesting the court to sell the property and divide the money. You know, now here's how developers get involved. If the developer buys the interest of one heir, they step into the shoes of that heir, and you've got a new family member, right? And they have the same rights as any tenant in common heir owner, including the right to force that sale and have the money split. And obviously, they're not interested in the little piece of interest they purchased from an heir. They're interested in buying it at the sale, right? And usually what happens, and historically what would happen, was it would sell invariably, almost always, for a lot less than what it was actually worth. By the time the lawyers got paid, by the time everything, all the costs are associated, the heirs got next to nothing for their little bit of interest. Even the heirs who were forcing to sell, the attorneys were rich, you know, depending on what kind of property it was, and then the people who bought it, who were more often than not a company that was part of forcing the sale, they develop it and turn around and flip it for a lot of money. And particularly along the coast, that was you know, Hilton Head looks like Hilton Head for a reason. And I'm not from the Low Country, so I'm not, you know, but the history down this way sort of lends itself to that narrative across the board. So that forced partition sale is a way, and I don't want to imply or give the impression that we're only talking about companies or predatory developers, because I could tell you one of the primary sources of forcing a sale are other family members, right? And that's because that family group, and more often than not, is because that family group has grown to the point that you don't have people that have a connection to it, right? You know, people that feel about it the same way as maybe my client who comes in the door who's lived there her whole life. The so those are some of the avenues for sale. I can tell you that the passage of the Uniform Heirs Property Partition Act in 2019 provided some protections. It does, by no means, it does not eliminate forced partition sales. Those still go on. What it does, it basically addresses the issue on two fronts. One, if there is going to be a sale, it's going to be a sale at market value. No more selling it on the courthouse steps at auction where it gets sold for less than the value. Now, that's good on one level, but if you don't want to sell the land, that doesn't matter a whole heck of a lot. It's still gone, right? And another thing it does, it gives the judges more room and more considerations legally to go through to decide whether a forced sale versus an action to divide the property would be better. Prior to the passage of that act, it was almost a foregone conclusion that if a family member or a developer brought a forced partition sale against the other heirs, that if the heirs couldn't buy them out, that it was going to be sold. So with the new law, there is some consideration to where that's not necessarily the case. But I never want anyone to think that that law did away with the problem, because it certainly didn't. And again, it only addresses the problem of forced partition sales, not tax sales, not anything of that nature. One thing I always like to address as well is if you have heirs property now, if you're an heirs property owner, or and this gets a little sticky because I've seen a lot come through the door since I've been with the center in 2009, and I've seen people come in having signed something for a family member they thought was one thing and it was actually another. So one of the first things I always tell folks is don't sign anything. It don't matter if it's not somebody you know, but even if it's a family member. I mean, the truth of the matter is that I've seen so many fraudulent deeds come through And the problem is once the person signs the deed, even though they didn't know it was a deed, and they pass away, and then their kids come in the office and say, well, my mother owned an interest in this land, and come to find out, mom signed a piece of paper that she thought was permission to allow a nephew to put a home on the land. But in actuality, it was the last page of the deed, which he just stapled the front 2 pages of the deed to the last page, recorded it, and mom dies 10 years later, and her kids no longer own an interest because that deed is presumptively valid in front of the court. And improving fraud after all the participants are gone and dead is near impossible. So what I tell folks is it's not a bad idea if somebody brings you something to sign. One, read it, and it depends on your level of sophistication. If you're used to dealing with this sort of thing, then you can read it. But if you're not used to dealing with it, it'd be like me trying to fix a transmission. I would be complete. It's not my in my skill set. So, there are legal aid organizations. Even if the Center for Heirs Property is not up to the upstate yet, uh, South Carolina Legal Services is a resource up that way. Find a legal aid attorney to at least run that by, or if you know an attorney on some level, to have them look at it, or even if somebody that you trust, that even if they're not an attorney, maybe deals in real estate or deals in something like that. Just be careful about what you sign. Two, get a will. Again, having a will can prevent an issue. Even if you have an heirs property interest, an heirs interest, you can will that interest to somebody, right? So we want to have a will. Um, the and if you're in a situation where the heirs are sort of paying the taxes while it's heirs property, even if they're working on the title issues with it, be sure there's a plan and a backup plan for paying the taxes. I can't tell you how many folks will come in and Aunt Jenny was supposed to be paying the taxes and something happened and Aunt Jenny didn't pay them and she didn't tell anyone. Maybe it was because she had too much pride or she was embarrassed or maybe it slipped her mind. Um, there should be somebody checking the assessors of the tax records to be sure that whoever's paid is supposed to be paid. That's becoming even more important because there are several counties here in the low country now that if it's heirs property, and this blew my mind, if it's heirs property, you can't redeem a tax sale without proving you're the owner, which you can't prove an owner within the year period. You can't bring an action to prove who the owners are and get a court order within a year. So ultimately, in that county, what it's basically done is if you have heirs property and it goes to tax sale, that normal year's redemption period where you can pay the taxes and the penalties associated with it and keep the property is not available. And we're seeing more counties adhere to that. Now, I don't know about Greenville or Anderson or some of the counties up that way. I'm not suggesting they will or are planning to. I don't know, but I know several counties in the Low Country are starting to do that, and usually that's sort of a domino effect because it makes it easier on them. So, um, how do you prevent heirs property? The idea of again having a will and understanding that heirs property is created every day, right? And and if you and your spouse own the property and one spouse passes away, the estate needs to be probated within 10 years from that person's date of death. So if you have a will and you do that, then you can resolve the issue long before it turns into this sort of really complex, complicated problem that can take years. I've got a case I'm working on now that we're in year 7, uh, it is extremely difficult because unless you can get everyone to agree before you get in front of a judge, you're putting the client in a vulnerable position because all it takes is a disagreement for a forced partition sale, right? All it takes is a group of heirs who say, I want to be bought out or I want it sold, you know. So, the center has been in existence since '05, and knock on wood, we've never been involved in a case where a family lost land. And we've cleared over 285 cases worth about $16.5 million worth of tax assessed property. And the only reason we can say that is we have mediation services as well. And we won't put a family in front of a judge until we have a mediated agreement. Um, I'll say this: if you're going to an attorney, if you're not going the route of a legal aid organization, or even if you are going the route of a aid organization, they may not have the same requirements that we do. If your first and foremost goal is to protect the land and keep it in the family, you need to tell the attorney up front, regardless of what strategy you want to use. You know, tell him or her that the first priority is you don't put me in a position where I can lose my land. If somebody else wants to go pay an attorney to bring me into a courtroom and try to force a sale, so be it. I can't control that. But don't you put me in a courtroom where all somebody's got to do is not even hire an attorney and show up pro se, and things go south and the property ends up on in a forced sale situation. That's and one thing I'll also say, I sort of forgot about this, the land utilization component. Another problem with the heirs property is if you own the property in a rural area and you have timber on it, you have trees on it, trying to sell the timber when you have heirs property is extremely difficult. If you can find someone to buy it, it's going to be someone who's going to pay you a lot less than what it's worth. Because technically speaking, to sell timber off heirs property as an heir puts you in you can be liable to the other heirs for the sale of the timber, as can be the person entering the contract. Because remember, there's no record of who the owner is, so who's signing the contract, right? So the timber harvester, the timber buyer, whoever's doing it is taking a risk. So they're gonna give you a lot less than what it's worth. If you can find someone to buy it. The bigger companies, they're not going to touch it because they want a chain of title of ownership. So that's another problem, and something that needs to be considered. The That's about it for purposes of this presentation. The idea of sort of laying out some of the basics, that each one of these topics can go a lot deeper, right? You can go a lot deeper on some of these subtopics, but I think the idea of a Q&A session and answering specific questions from folks is a good idea. And I would say this, I have to give a bit of a warning. The devil's always in the details, right? So if it's a really, really, really specific question, I can't answer that, not because I don't want to, but because the amount of information I would need to be able to give you an answer that I can rest assured is the right answer would take longer than what we're doing here already. So if it's a general question, I'll be glad to answer it. I'll answer it in the abstract. And the truth is, as Mr. Mitchell put in the chat, anyone in South Carolina can get a free hours consultation with the center attorney. Now the land's got to be in those 22 counties as listed there for extended representation. But if you're in South Carolina, the land's in South Carolina, and you're an heir, you can have access to an attorney at no charge. And you just need to call either the Charleston number or the Orangeburg number and set up an intake appointment with an attorney.
Okay, thank you, Attorney Walden. Now, before we get to the specific questions, Attorney Walden, you have 5 points that you were hitting tonight, and I just want to refresh everybody on those 5 points. So what I will do is ask you each one as a question, and you, if you would, give us the 50-cent short answer as to the answer to the question. The first question is, what is heirs property?
Okay, there is no easy answer for that. That whole spiel at the beginning was the answer to that. Heirs property is just property owned by heirs of someone who's passed away, and it's been 10 years since they passed away, and they died without a will or estate administration.
Okay, very good. See, that's the 50-cent answer, everybody.
There you go.
Number 2, what are the problems associated with heirs property? You don't have to name all of them, just some of them.
Sure. Primarily, the inability to prove who the owners are, lack of access to the value of the property, by way of equity or otherwise, and the vulnerable nature of that family continuing to grow and that group of owners becoming bigger.
Okay. Number 3, how can owning heirs property lead to a family losing their land or home?
Forced partition sales, family disagreement, and tax sales.
Okay. Number 4, if I have heirs property, how do I protect my land and or home?
Get a will and don't sign anything without having an attorney look at it.
Okay. And the last one, number 5, before we go into questions, is how do I prevent heirs property? How do I prevent that whole concept of heirs property even occurring?
Have a will, and when someone passes away who owns property, have their estate administered in the probate court. That creates the record of who the owners are, which is the entire problem with heirs property. You don't know who the owners are. And obviously part of the ways to protect your home is to contact a legal attorney, contact an attorney or a legal aid agency to start resolving the heirs property issue, because it only gets bigger, it only gets more complex, and as hard as it is right now, it's never going to be easier than it is right now. It's always, it's not static, it just grows. So
Okay. Well, those are the 5 points we really wanted to hit for everyone tonight. And I wanted to do a summary so that everything would be fresh in everyone's mind. As I look at the chat, I don't see any specific questions. So we'll open it up to everyone in this meeting to see if anyone has a question that they would like to ask Attorney Joshua Walden. If you'll unmute your microphone, then you can ask your question.
I have a question.
Go ahead.
What is the percentage of heirs property that have lost annually?
wow, that's a great question. We don't know, to be honest with you. We don't know. We know that when you're looking at when you're looking at the land loss, I could tell you that we see over roughly before COVID, between 400 and 500 people a year with heirs property issues. You're not the first person to ask that question. As a matter of fact, a lot of funders ask that question, right? How big a problem is it? What's key to that question is how you have to find the answer. And in South Carolina, for purposes of that, there are estimates, but in South Carolina, you'd have to check the rolls of the clerks of courts office or the master and equities courts to see how many forced partition sales have happened. Then you'd have to dig deeper and see how many of those were heirs property, because forced partition sales happen all the time that aren't heirs property. The two of us could buy land together, and one of us could bring a forced partition sale against the other. The forced partition sale is just available anytime more than one person owns land together. It's just in heirs property, you're dealing with a group of heirs who happen to own heirs land together, and those rights apply the way they would for non-heirs owning land together. So I wish I had an answer for that, not only for you, but for a lot of the funders. We know that it's enough of an issue that at this point, I think 11 states have passed the Uniform Heirs Property Partition Act. Heirs property has been addressed in the 2018 Farm Bill, the USDA. It is a national scope issue, and oddly or uniquely enough, it seems to be along the coastal plain, the Gullah Geechee corridor, the coastal plain stretching back in, but also the same problem is in Appalachia. Same problem is in Southwest. It's an issue that's pretty pervasive, but I really don't have a number for the land loss.
Okay. Is there another question?
I have a quick question.
Okay.
What if there's a married couple and one of the spouses does not have a will and one of them is deceased? becomes deceased due to whatever, what happens then with the part that the person owns that, you understand what I'm saying?
Yes, ma'am.
You got joint property together as a married couple.
Yeah.
Then one of the spouses dies and one of them does not have a will. What happens to the properties, businesses, or anything that the couple may have had jointly together when one of the spouses does not have a will, but everything is joint?
Okay. So, and I'll repeat the question to make sure I got it right. So you got a married couple and one of them passes away without a will, but they own the land together or the home together,
Yes.
right?
Yes.
Well, when did they pass away? What year?
Well, yeah, it's been just a year ago.
Okay.
Last
See,
year.
There's different law that applies. So if you told me before 1986, I'd have to give you a different answer. So
yeah, this was just last year.
Okay. So under the law, if the person died without a will, then wife is going to inherit 1/2 interest in everything that he owned, and his children will inherit the other 1/2 interest.
Does it go past the children? Does it go to any of the children? The
It can go to the
grandkids of
grandchildren.
the child of, you can have outside children in the relationship, the extended family thing.
Yep. Generally
So
speaking.
how far deep does it go into that portion with his side of his family's interest, so to speak?
Well, whatever interest that individual owned when he passed away is going to go under the probate code law. And what that is wife's going to get 1/2. If he has any living children, they're going to split the other 1/2. Let's say he had 2 children, right? Well, the 2 children are going to split that 1/2 and get a 1/4, or, well, it's not a whole, but the 2 children will split 1/2 of the estate and the wife will get the other 1/2. Now, if he had 3 children, but one of them's deceased, and that child died before him,
yes,
then the grandchildren will inherit that one.
That's when the grandkids kick in.
But it won't flow to the grandchildren of the other 2 children because they're still living.
Yes.
Yeah, it only trickles down once someone passes away. And as far as outside children generally inherit. And so yeah, it's one of those things that comes up an awful lot when we're putting together family trees and it's multiple generations. And I tell folks, if he showed up at the funeral and he looks like him, you need to include him because we don't want him showing up at the hearing after we've run the publication, because he won't be in a mood to negotiate at that point. So but yes, ma'am.
So does that affect the probationary part of the estate when they're going through that process, if it's like that?
No. What would happen in that instance if let's say the wife came into our office, right? What I tell her is, okay, we need to probate his estate through the county's probate court. Since he passed without a will, there's some paperwork that has to happen that all those kids have to be named in the probate process. The wife has to be named. It's a process that can take anywhere from 8 months to a year, but it's mostly paperwork, whoever, it's not something that's that involved. It really isn't. Now, paperwork wise, family wise, I don't know. You know how that goes.
Yes.
So, but I can tell you that if it shouldn't affect it one way or the other. I mean, it might make it a little more complex about the people you got to notify and the people that are involved, because there's a bigger group if it goes that far out.
It just takes a little bit away from rather than the person getting the full amount of the estate. If both had the wills, they only lose the part that would have been generated by the spouse.
Well, that's just it. If the spouse would have had a will that said, upon my passing, I leave everything to my wife if she survives me. If she does not survive me, then to my children. That would have been no problem. You just probate the will. Mama inherits it all and she owns it all.
Oh, right? Okay. All right. Right. Thank you. Been very thorough. Thank you.
Sure.
Alan.
Thank you for that question. Glenda, go ahead.
Thank you, Alan. Who benefits most when heir property is lost? I heard you say the developers get a piece of it a lot of times. What other entities benefit when heir property is lost?
Yeah, that's a good question. I mean, we always think offhand, we always think about developers and acquiring land and acquiring homes. That's a good question, because generally speaking, it's anybody that has a monetary interest in gaining that property, right? I mean, it's anybody that property being, being, for lack of a better word, legally stolen, you know, out from under folks. And I should, you know, and that's not always the case. Sometimes a family member forces a sale, so it's not always an outside party. Um, so I don't know, you know, when I always look at it, I never look at that part of it. I look at it who loses the most, and the people who lose the most are the family. I mean, maybe the next door neighbor, you know, is going to buy that lot, so he's going to benefit, right? Or maybe the developer who's going to turn this field that the family used to have as a garden into a parking lot, you know, or sell it to Walmart or something. They're going to benefit. The tax base, maybe the county, you know, maybe if it's turned into something that generates a higher tax return, maybe the county. So we always seemingly focus on the folks who are losing the most, because a lot of the benefits that other people can realize, the heirs can realize if they get their property straight, right? All those benefits that seem to occur to other people can be owned by the family.
Okay, we have a question in the chat. Would a family trust or LLC provide additional protections for heirs' property, or is a will still a better option?
Sure. Well, the trust or the LLC, you're still going to need clear title. Because remember, to establish a trust or form an LLC, you need to know who the owners are, right? So an LLC or a trust is a great way to prevent heirs property. But once it's heirs property, as is a will, it's just depending on what you want to do. That's a great way to prevent heirs property, or after you clear title, if there's a specific purpose that everyone agrees to, because you're still going to need full agreement amongst all heirs to go the trust or the LLC route, which can be another family mediation point, because some people just I want my piece and I'm out, right? I want my piece cut out, and me and my family will handle our piece if it's a large tract. But trusts are great tools, as are LLCs, depending on what the family, if they're in unison and they're in agreement, will want to do. But either way, either one of those options is going to require clean title. So that the title issue still has to be resolved.
Okay, thank you, sir. We have any other questions? Don't forget you need to unmute your microphone so that we can hear you when you ask your question.
I've got a question, Mr. Walden, Carl McIntosh.
Okay, Carl, go ahead.
And work with Alan. I'm an attorney, and I deal a lot down in the low country, and we have these issues of quiet title actions need to be instituted or filed, but most of the families financially are unable to afford an attorney for quiet title action. Does your organization provide that service? And if so, what's the criteria, or is there a limit on the individuals as far as financial limitations on the individuals, or what criteria do you have if you provide that service for quiet title actions?
Yes, sir, we do. I mean, across the gamut, we administer estates inside the 10-year statutory period. We bring, we determination of heirs actions, quiet title actions, on occasion partition actions in kind. We don't accept clients who want to sell. We assume they have more options than other folks who want to keep. The criteria is the property has to be located in one of our 22 service counties. The individual applicant has to be an heir. They have to qualify their household income at the 200th percentile of the family poverty index. And they understand that ultimately we're going to require a full mediation among all heirs before we move forward. But we do bring quiet title actions. We handle all those actions. I could tell you what happens a lot of times, Mr. McIntosh, is that our requirements sometimes seem more burdensome to a client than maybe a private attorney. The idea of we require a mediated agreement in order not to put a landowner in jeopardy in front of a judge without an agreement amongst all the owners. Um, so if you go to our website, there's a if there are folks in the Low Country that perhaps you've worked with that maybe are looking for a quiet title action and don't have the resources to pay a private attorney, because I'm sure you can attest it is extremely a time-consuming endeavor. Um, and then you could certainly refer them to us. Um, that that 200th percentile based on size of family household is something that you can pull up online, Google it, and it'll tell you. I don't have those numbers in front of me, but that those are basically the requirements.
Okay, Mr. Walden, if you don't mind, for those who may not understand what a quiet title action is, could you explain what that is in layman's terms, please?
Sure. A quiet title action is really about filling in the record of who the owners are and getting a court order that says these are the only owners as against the entire world, right? So you're doing sort of two things. You're sort of filling in the gap of that chain of title we talked about, that record of who the owners are.
Mm-hmm.
People, after John Smith died in 1950, people still had babies and died and had babies and died. So we fill in the record of who these owners are and what percentages of the property that they own. But we're also, the court's issuing an order saying these are the owners and these percentages as to the whole world. There's nobody that can come forward and make a claim on this property. That's in essence what a quiet title. And generally, you're also perfecting or confirming the bounds of the property, the boundaries of the property.
Okay.
Quiet title.
Do we have another question from anyone on the
Chat.
call?
Oh, I have a question in my chat.
Helen, go ahead.
Oh, okay. Well, I'll just read what I had. If I live in Maryland and I have a will that says I'm giving my property, my heir property away to somebody else, and then I die, does the South Carolina law recognize my Maryland will regarding the property that I want to give away?
If you're in Maryland, the process would be an ancillary estate in the probate court in South Carolina where the property is located.
So you're saying it would
Yeah,
be
you could have the attorney handling it in Maryland, contact the probate court in the county. What county is well, you don't need to tell me what county it's in, but you know, the idea that you could file an ancillary estate and submit the will for acceptance.
also, so my executor or whatever would have to do that.
Yeah.
Okay, thank you.
Sure.
Okay. More questions? Either put them in the chat, please, or just open your microphone and I'll recognize you.
I have a quick question. As regards, I just wanted to confirm that you said that you can't see the value of a home in heirs property. Was that correct?
You can't access the value in the form of getting a loan that takes into account the equity rather than the value.
Okay.
Yeah.
Josh, could you give an example of that so everybody's clear?
Sure. Well, I mean, a lot of people, if they have a home and let's say it's on a piece of property and that home's valued at $85,000, right? And if they don't have a mortgage, then they should have access on some level to $85,000 worth of funds that could be leveraged against that property, i.e. a mortgage. You know, maybe they want to borrow $10,000 to put a new roof on the house, right? And if it's not heirs property and they have decent credit, they should be able to go to a bank and get a mortgage on that property or an equity line and be able to pay for that. If you have heirs property, you don't have that ability, because the first thing the bank's going to want is a title search. And then the title search is going to show that that record of ownership stops in 1950 with our guy, Mr. Smith, right? There's no proof of who the owners are and the title's unclean. And so you don't have that ability as most homeowners or landowners do.
Okay. Thank you for that question, Jasmine. More questions. This is a great opportunity, everyone. You may have heirs property, you may not have heirs property, or it may be a situation where you have heirs property and you don't even know it. And it'll come to you as a surprise when somebody does an action. So no question is too simple, and no question is out of line. So if you have a question, please ask it now. Otherwise, we will begin to move on to the close of our meeting. Unmute your microphone and raise your question. Okay, there's another question in the chat. Would you advise Helen and Marilyn to give her portion to another person before she dies, so the executor does have to deal with the situation, or does not have to deal with the situation?
Well, I mean, that would be up to her. I mean, if she wants to make it, if she doesn't want it to be part of estate consideration, she could certainly have a quick claim deed drafted, and that's just a deed that says whatever interest I own in this particular piece of property, I'm giving to so and so. So if she had a relative in South Carolina who maybe lives on the land we're talking about, or a relative in South Carolina who has closer ties, and if she doesn't want to keep the interest, then certainly that is an option, and it's a way. Of course, you're giving away your ownership, and you're giving away the rights of any of your heirs to inherit a portion of that ownership. So if you do that, you just need to understand that that is truly giving away your interest in the land, regardless of what happens down the line.
Okay, I have a question related to the heirs property and the value. When you look at a tax record, you see the tax value and you see the estimated market value. If you're selling heirs property, you said now there are some laws that will try to help people get the actual value of the property. But if you're selling heirs property, is there a guide that the owner or owners can look at in terms of those numbers on the tax records that will give them some idea of what the value of the property is?
Yeah, well, the idea of getting market value is in the context of a partition sale action, right? An individual just wanting to sell their property, remember, they can only sell the interest they own.
Right.
Right. So if they own 90, they sell 90%. If they own 10, they can sell 10%. As far as estimating a value, that is completely up in the air, because usually an appraisal is going to be based on the fact that there's clean title and they can determine who the owner is. The fact that it is theirs property makes it a lot less valuable, because any buyer is only buying the interest of the person who's giving him the deed or giving her the deed. You could look at the tax assessed value of the property or the market value on there, and maybe use that as a guide. My question would be, can you find a buyer gullible enough to buy it, knowing that they're buying into this issue, right? Generally speaking, and this is just my experience, I'm not speaking to specific circumstances, but anybody willing to buy heirs property at face value, generally speaking, they've got minds, and particularly if they're not a family member, they've got a mind to get into that group and possibly try to force a sale or begin some kind of work in that way. Again, you're only selling your interest. So how do you determine what the value is? Do you equate it to what your interest is? And even the market value isn't a true reflection of the value of the land, because any buyer who has any knowledge knows that they're either going to have a title search to to understand the status and the status of the title, and understand, and then they're going to realize that the title does have a cloud on it, as they say, and they're not going to want to buy it, or they're going to buy it for such a small amount, you know. So that's just sort of like the Wild West. I mean, if you're, you know, you can look at the market value and you can kind of see what your interest is if you want to come up with something. Now, where I do hear that come into play sometimes is when heirs are together, right? And some heirs say, you got to buy me out, right? And then I've had clients or heirs in the group say, well, like that old 10 acres and 10 heirs, right? Let's just use that. And if I could do math, I wouldn't go to law school. So we'll say it's worth $10,000, right? So if one of the heirs says, buy me out, and the rest say, okay, we'll give you $1,000, right? So that's 1/10 of this 10,000 value. And they go, no, I want 5,000. Well, guess what? You can't make them take 1,000. A court can't make them generally take 1,000. You know, that's another problem with heirs property. Their interest is in the undivided whole, right? So they can kind of hold people hostage. You know, heirs can hold other heirs hostage sometimes. But yeah, that whole valuation for purposes of sale becomes extremely tricky when you're talking about heirs property.
Okay. Well, you got to the point that I wanted you to get to, so that was a good answer. Sylvia, you have a question? Okay. Anyone else have a question?
Alan, there was a question in
Yeah.
the comment section on Facebook. Can adverse possession come into play with heirs property? For example, one relative has lived on the land, made substantial improvements to the property, and has paid the property taxes for a number of years exclusively.
Great question. Yeah. Adverse possession or squatter's right. Just the description that Ms. Brewster just set forth, that someone's been on the property for X number of years and paid the taxes. First and foremost, the payment of taxes for 40 years does not make a particular heir any more the owner than their interest would indicate, right? The payment of taxes is the act of one heir on behalf of all the heirs. However unfair that sounds or is, you know. Adverse possession, there's a certain legal process by which when someone is on a piece of land long enough and it's open and notorious and in direct opposition or direct in the face of the rightful owners, that the court will say, you've been there long enough that you've acquired an interest in this property. These other people have slept on their rights because you didn't have an ownership interest. They knew you didn't have an ownership interest. They knew you were there. You were open and notorious about it. You didn't hide, and they just didn't do anything. And you've, over the course of time, have come into an equitable interest in the property. That's basically squatter's rights or adverse possession in the simplest form. Now, between heirs, basically as between any tenants in common, or particularly between heirs, there's an extra requirement in there called ouster, that there has to be a pushing out of such a level that it rises above just living there against people's will. Here's the problem with adverse possession in heirs property, and it's the reason the center doesn't handle adverse possession cases with heirs property. One, we require an agreement, and adverse possession by its very nature is adverse, right? There is no agreement. The other problem we have is that what you've got to be careful of is, remember, all the heirs have equal rights to live there. So what level of ouster do you have to show when everybody else knows you're supposed to live there? How is it adverse to them, right? Now, I'm not saying there aren't attorneys who bring those actions and attorneys who aren't successful with those actions, but I can tell you, in my opinion, it's a dangerous game to play with heirs property, because it wouldn't take, you know, if another heir comes forward with an attorney, right, because they're being sued for adverse possession, and maybe the one person who's lived on this 6-acre tract has always lived there and farmed it, and there's 40 other heirs, and they sue those other 40 heirs for purposes of adverse possession because they've been there for 20 years. If one of them comes back with an attorney and basically defends against the ouster provision in an adverse possession as between heirs, and wins, and then counterclaims for a forced partition sale. You could go from trying to get full ownership to the property being sold out from everybody and the money being split. So that's one reason we don't take cases that have an adverse possession component to them. I guess Mr. McIntosh would need to know that too before he refers anybody. That's another thing. It goes along with the agreement requirement. It's not something that's out of bounds. It's not something that can't work. It's extremely difficult, in my opinion. And as I stated at the beginning, if you're working with an attorney and if your first priority is to protect the land, adverse possession as between heirs, absent some pretty extreme circumstances, is a dangerous endeavor.
Okay. Thank you, sir. All right, everyone. I don't see any more questions in the chat, and I don't see any more people unmuting their microphones. So at this time, I would like to thank Attorney Joshua Walden for his presentation representing the Center for Heirs Property in Charleston, South Carolina. Don't forget, the information is in the chat. You can copy that information into a Word document. Center for Heirs Property Preservation, www.heirsproperty.org. There's a phone number for the Charleston office, 843-745-7055, and the Orangeburg office, 803-987-4481. And please, please, please do not hesitate to reach out to Attorney Walden, to the office in general, and take advantage of what they have to offer. Don't forget, you can get an hour of consultation. And if you have property in one of the 22 counties, you can get even more service. So at this time, I will turn the program over to our producer, Ms. Alicia Brewster, who will tell us about the survey for the Nicholtown residents and about upcoming events. Our next scheduled housing event would be July 8th. We will see if we're going to still have that one since that's the week of the 4th of July. But it will be on the website and we will be notifying everyone about our schedule. So Ms. Alicia Brewster, it is all yours. Thank you, everyone.
Thank you, Mr. Allen Mitchell. Thank you, everyone, for being here. Thank you, Attorney Walden. For many of you who may not be familiar, because I saw we have people from Washington, D.C. and Maryland and other places throughout the state, throughout the country. Sustaining Way is a nonprofit with a base of operations in the Nicholtown community of Greenville. We use education, collaboration, and advocacy to create sustainable, caring, and equitable communities for current and future generations. So this is a very important seminar, or 60 or so minutes that we've spent together, specifically talking about heirs property, because it's important for current and future generations that we are preventive in creating the circumstances for heirs property. And of course, if there is that situation where you find yourself as an heir owning heirs property or having interest in heirs property, it's great to know that the Center for Heirs Property provides all of the services that they do. So again, thank you. And there are so many different services that they offer, from the prevention side of things, like drafting wills, especially for those who live in the 22 counties that were mentioned, as well as resolving issues and land use topics as well. So thank you. And we're going to provide a short survey in just a minute to see if there are any other topics that you would like to hear from the center, as well as other housing specific topics. As Mr. Mitchell mentioned, we do have a survey also for our Nicholtown residents. If you are a Nicholtown resident, Sustaining Way has partnered with the American Heart Association, South Carolina Thrive, Favor Greenville, DHEC, and the Phyllis Wheatley Center to facilitate a community health survey. So if you haven't already participated, we do ask that you please take our anonymous community health baseline survey today to help us understand what resources we may be able to work together to provide. So I will put the link for that survey into the chat now. And we do ask that if you have not already taken it, that you will take time to complete the baseline survey. And then I also want to share my screen because we have a wonderful community event coming up very soon that I hope if you are in the Nicholtown community or if you will be near the Nicholtown community that you will be able to participate in. We will be celebrating Juneteenth on June 19th at the Phyllis Wheatley Center in the parking lot. We will have live music and entertainment, a market, a neighborhood market, kids activities, double Dutch even. So we are going to have a great time celebrating Juneteenth together and celebrating the resiliency. I remember when I first met Alan and I was asking him, what can we do? He said, you know what, we want to survive this pandemic. And thankfully, we have come to a point where I think we can celebrate that most of us have been able to survive and we are looking to thrive now in a healthier, safer environment. So this is where you can go to get your ticket for our Juneteenth community celebration. It will be 1 to 4 p.m. Again, at the Phyllis Wheatley Community Center in the parking lot. It is completely free. And we also will be doing a special recognition for our fathers. So please do nominate the special fathers in our community who are so important. And Father's Day will be the next day. And we will also have some wonderful community members who've been in the community for several years who will provide history, the history of Nicholtown. So it should be a lot of fun as well as very educational for those of us who did not grow up in Nicholtown to be able to learn some of those facts that we don't know about Nicholtown. So at this time, I'm going to go ahead and launch the poll for everyone to take. So if you are still with us, we would like for everyone to take this poll to give us some feedback about this event and about how you heard about the event, as well as other topics, housing topics you would want us to cover in the future. And then I'm going to, in the chat box, put the link because it didn't work the first time for our baseline community health survey. And if there are any other events, community events that someone would like to tell us about that would be useful for the greater good, we invite you to share that as well. And you can unmute yourself and share with all of us if there's something great that's going on that you think we should all know about. We're going to keep the poll up for just a few more minutes. So it looks like 10 of us have completed the survey. So for just another 30 seconds, we'll keep that poll open. And again, we do invite you, if you live in Nicholtown and you have not already completed the community health survey, to please complete that.